I do not think I was unclear, okay? I was very clear with you that the redundant part, the repetitive part was what wasn't going to be okay, okay? And by the way, if you smirk when I'm having this conversation with you, I'm going to think you're lying. So continue to smirk and I'm not going to believe what you're saying, okay? That's the impression that it's giving, okay? So if you are telling the truth, please do not do that, okay? I'm giving you 3 minutes to get up and put your form up there. That's it. We're not playing some crazy game right now, okay? That's it. Now, they're going to... Okay, please strike the last comment from counsel. That's not a law that I've instructed you on. So I'm instructing you please to not consider that in your evaluations in this case.
Okay. We do not have to hire experts, and you will not see an instruction in your packet that says we have to hire experts. It's not in there. We are entitled to just simply cross-examine any experts that go before the court that plaintiffs bring because they ultimately have the burden of proof. And that's what we did in this case. We cross-examined those experts and we did not need to present any other experts for our case. Now, I want to talk about the accident itself. We have 2 drivers here, each of them making human errors. Human errors are expected when we're talking about drivers, which is why we set the standard of liability to be that of the reasonable person. We heard about that a little earlier, the reasonable person. That's not just Zaon. Eric needed to be the reasonable person as well. So both drivers need to be reasonable people in those roles. So what does that mean? What does being a reasonable driver mean? For Zaon's part, it means to follow the speed limit. We acknowledge that he did not. Okay. But it also means that a driver turning left must yield to opposing or to oncoming traffic. We heard counsel's opinion that the right of way didn't apply here and that Eric didn't have a duty to yield. But we also heard from an officer and Mr. Terry himself. If we could play those clips, please.
So when you turn, you know the car is speeding, he's going to run the turn.
So who went the right way in the collision that you prepared opinions for today?
On approach, Mr. Collins would have the right way.
Generally, people are able to perceive speed, correct?
At a point in time, yes, there's when they get close enough, there's a realization that there is a speed differential as they get closer.
This jury instruction you saw earlier applies to Eric as well. So every instruction that you're going to see, and if we could pull back up the law on the failure to yield, please. This jury instruction, despite plaintiff's opinion, applies to Eric as well. Okay. Now, when we talk about the law applying equally to both Eric and Zaon, that means that Eric had a reasonable right to expect that Zaon would be traveling at or near the speed limit. But Zaon had a right to expect that Eric would not make that left in front of him. It is expected that Zaon would follow the rules of the road and the safety rules. It is expected that Eric would follow the rules of the road and the safety rules. So let's talk about what else makes a reasonable driver. Not being a distracted driver. We heard that Anne-Marie states that she was not on the phone with Eric.
I don't know, I just asked you, the accident just happened. What, you were on the phone with him? Okay, where was he coming from? Okay.
I was on the phone with him and I heard all of this rumbling. He was coming back from Wendy's. If we could jump to slide 22, please. Finally, a reasonable driver is a defensive driver. I want to have another look at this footage. I know that plaintiff doesn't like this footage. It shows what the numbers can't show. They called it misleading. It's the video. It is what it is. It's the video of the crash. So I want to talk about this video a little bit more. We're going to zoom in a little bit more, even though it gets really grainy, because I want to talk about what happened here. We see Eric pull up. We see him begin to take that turn, pause to let that car pass. And we see Zaon coming up, and he cuts out in front of him and tries to beat him. Could we play that zoomed in version one more time? We know that from this footage and the data from the vehicles that as Eric began his turn, he realized the mistake. And instead of braking, he tried to speed up.
Objection as to he realized, Your Honor, it's speculation.
We know that from this footage and the data from the vehicles, that as Eric began the turn, instead of braking, he sped up. He tried to beat Zaon as Zaon also tracked right. Okay. What you did not hear, ladies and gentlemen, is that it was reasonable for Eric to speed up to avoid the collision. You did hear that Zaon's defensive maneuvers were expected. He slammed on his brakes immediately, engaged that ABS lock, and swerved to the right to try to avoid the crash.
Based on the data provided, did Zaon brake aggressively or just slowly braked?
It was a full ABS lock, so it was aggressive braking maneuver.
Now, when you talked about him tracking right and following the path of the Hyundai, did you find any evidence that that was an intentional or was it just an evasive move?
It's common,
Well,
very common.
So ladies and gentlemen, I want to talk about the burden of proof. In this case, the burden of proof matters. And the burden of proof matters not only because we are alleging comparative fault between the two drivers, but also because there's going to be two different burdens of proof involved here. One is that standard of more likely than not, and the other is that clear and convincing evidence standard. And it's very important that you understand the difference between those two burdens of proof. So let's talk about the legal cause, the more likely than not standard. We have alleged that Eric bears some responsibility for this crash. Now, this jury instruction tells you what a legal cause is and if someone's conduct is a substantial factor in causing the harm. We are asking that you assess Zaon's speed and Eric's failure to yield as both legal causes of this accident. We are asking you to apportion fault between these two drivers. And again, we do this not because Eric is a bad person. We do this not because we think Eric is totally at fault for this accident. We do this because both drivers here made mistakes. Zaon was speeding and Eric was in a hurry and failed to yield. So we are going to be asking that on that jury form that you apportion fault. Okay. Again, this process, this civil process is designed to account for human error. And ladies and gentlemen, you can award whatever percentages you want there. What I suggest, what they suggest, you don't have to listen to any of us. You do what you feel is right. But that's what we're asking. We are asking for you to apportion fault because this process is designed to account for those human errors made by both drivers here. And every person in this accident must take responsibility for their own actions. And while it is unfortunate that Eric perished as a result of this accident. It does not mean that he is automatically fault-free. Zaon was speeding. We know that. He was charged with reckless driving and vehicular manslaughter as a result of his speeding. You've heard all about that. He is currently paying his debt to society.
Objection, Your Honor, move to strike paying debt to society.
I was allowed to say that in opening even.
So your response is,
I've already said it.
You
I said it
waived
in
it?
opening.
and your,
Irrelevant to the issues at hand, which is liability and damages, Your Honor.
okay, can I have counsel approach, please?
Okay, let's go back. So Zaon was speeding. He was charged with reckless driving, vehicular manslaughter. You have all heard that. He is currently still paying his debt to society. Now, criminal cases are the state of Nevada versus Zaon. They do not parse out percentages of fault. That is why we are here in a civil matter, to parse out percentages of fault. So whether or not Anne Marie approves of that sentence, that's not before you. That's not for you to decide. That was already decided, and it is not an issue for you to decide if you agree, disagree, have an opinion on. It does not matter. Plaintiff has proposed to you several times now that Zaon has escaped or evaded his responsibility. In fact, what he's done is exactly the opposite. He pled guilty to crimes stemming from this accident and was sentenced. He was convicted. You heard that plaintiff was upset with the criminal attorney. He's not here. Mr. Chesnoff is not in this courtroom. He's not involved in this case. He has nothing to do with any of this. You never heard her say Zaon said any of those things. So if Anne Marie is upset, I understand, but that's not what this is about. We are not here to right the wrongs that she perceives in the criminal matter and what the criminal attorney said and what the criminal attorney did, when that's not an issue in this lawsuit. We have not said a bad word against Eric or that family this entire trial, nor will we, because that's not what this is about. It is not about whether or not people are upset with each other or angry, because yes, at the base of these claims, people are angry. But you have instructions. You are the neutral people that have to set those emotions aside and set that sympathy aside and overlook those that anger that is coming from Anne Marie, and come to a fair and reasonable decision in this case. So I request that you evaluate that as your task and keep it in mind as you deliberate. You're being asked to assign civil liability, monetary damages, award a reasonable amount of monetary damages to compensate the family. You are not being asked to extend Zaon's criminal sentence. Plaintiffs also claim simultaneously that Zaon does not take responsibility, but then they play all the testimony of him doing exactly that. You did not see testimony from Zaon that he thought speeding was right, that he didn't think he was speeding, that he thought that it was just perfectly fine for him to be going that speed. You didn't, in fact, you saw the exact opposite. You heard Zaon admit he made a mistake and that he's sorry for that mistake. So while Zaon was speeding, he's owned up to his part in that repeatedly through this trial. You've heard nothing to the contrary. Eric made his own errors as well. He was a distracted driver, tried to turn in front of another car before Zaon, lost his patience, and then cut across Zaon when he had a clear path behind Zaon for 10 seconds before the next car. He could have just waited. He could have just paused.
Objection is to the 10 seconds, Your Honor. It's not in evidence. There's been no testimony about that.
Response.
Mr. Terry testified to that on my cross.
That there was 10 seconds between the car behind him?
Yeah, so by the time Zaon passed to the car that came. There was.
Okay. What I'm gonna instruct the jury right now is, look, these are closing arguments. You've kept notes throughout this and you've heard all the testimony and all the evidence, so base things on your memory of what occurred as to what was actually said, because unfortunately, it's near impossible for us to go back and check every single fact. So, I understand the argument from plaintiff's counsel, and I'm sorry, but we don't have access to the transcript immediately. If you guys want to pull it out, we can approach and pull it out.
Understood, Your Honor.
Okay, do you want to approach and deal with it?
No, I think it's, we've been addressed. It's been addressed.
Okay.
Thank you, Your Honor.
So go ahead. The jury is supposed to base what they believe the evidence was on their memory, please. Go ahead.
Thank you.
And when I put it over here, I meant the witnesses that you hear from.
So clear path after Zaon, he could have just waited. He then did not try to brake as he realized his mistake. Instead, he slams on the gas and tries to outrun that mistake. Perhaps if he had braked, Zaon would be the only car going through that wall.
Objection calls for speculation.
Sustained.
Now that we've talked about the burden of proof for negligence, let's turn to the impairment issue. This is the issue that requires that different burden of proof. When we were down here at that more likely than not, this is the one that requires you to go up. Clear and convincing evidence. Again, we did not hire a toxicologist to rebut Dr. Kelly because we did not need to. Dr. Kelly testified on cross-examination, and we accept that testimony from him on what we found out on cross-examination, and we'll get into that in just a moment. So what plaintiff is asking you to do is find by clear and convincing evidence that Zaon violated this statute, that he was willfully consumed, can we go back to that one? Willfully consumed a controlled substance and caused actual harm by virtue of consumption. They are asking that you find by clear and convincing evidence that Zaon was impaired and caused this collision because of that impairment. You will read punitive damages are an extraordinary measure. They are not a matter of right. They are never, they are not intended to compensate. They are not intended to make a plaintiff whole for their damages. They are strictly to punish.
Your Honor, I don't see the word extraordinary in that jury instruction.
Okay, it's argument. Go ahead.
So let's talk about the actual impairment. We heard from several witnesses that Zaon had no signs of impairment. We heard that the per se levels of THC do not equal impairment. Would you agree that a per se limit of THC in the system may not always reflect impairment?
Yes, it would.
You heard that levels of THC metabolite are not psychoactive and do not indicate impairment. That the THC metabolite can persist in the blood and urine long after impairment has resolved.
Yes.
And therefore, the metabolite can provide evidence of exposure, but does not indicate impairment. Would you agree with that?
True.
You also heard that most of the field sobriety tests could not be performed, but they found no odor. They found no coating on the tongue. They found none of those telltale signs of impairment outside of Zaon having red eyes after being in a traumatic accident. They next try to point to possession. Possession of marijuana in the vehicle. The evidence showed you that the marijuana container found in the car, you heard the evidence that was Marvin's and contained nicotine. And what were the results?
Nicotine.
and 0.067 grams of THC.
Earlier, we asked you about this document, it only includes the nicotine, about 8 grams of THC were found.
Yes, 0.067.
0.067 grams.
Yes,
You know how much that is?
that's small.
It's not a lot.
No.
Very good. Very good.
Oh, yeah.
I want you to have a perspective on what 0.067 grams is. It is about equal to a grain of kosher salt. Now, you also heard that the grand jury failed to indict Zaon with a DUI. There's a joke we hear in law school about grand juries, that they will indict a ham sandwich if that's what you put in front of them. They still failed to indict Zaon on this charge. Zaon was not convicted of this charge. The DA dropped this charge. Why was this charge dropped? Well, in large part because of Dr. Kelly.
Speculation, Your Honor.
Sustained.
So plaintiff's own expert, Dr. Kelly, discussed why he couldn't meet those burdens of proof for that criminal matter.
Because in a lot of their cases, I can say to a reasonable degree of scientific certainty that somebody was impaired. I just didn't feel like I could here.
But you feel like you can meet the lower civil burden of more likely than not.
Yes, I consider them quite different.
Okay, and my question is, that's where you draw the line, you can't get above more likely than not, that's where you're landing on this.
That's fair.
That's fair. He draws the line at more likely than not. Is that the standard for clear and convincing? Not to put you to the test, but it's not. More likely than not down here, clear and convincing up here. He can't get past this bar. He admitted it. So the whole story that plaintiffs believe Zaon created, if that's a story, why did Dr. Kelly admit that he couldn't meet that burden of proof? You heard it from his own mouth. He cannot meet the burden of proof above more likely than not, and that is what is required for the marijuana issue. So ladies and gentlemen, you can take plaintiff's attempts to show that Zaon was impaired and that there should be a punitive damages award with their evidence, a grain of salt. Now let's turn to damages. Here's where these cases do get tricky. It is one thing to focus on the cold, hard facts. Speeding, failure to yield, defensive driving maneuvers, all of those we can analyze the data. We can see what happened. We can recreate what happened. There are some damages that Dr. Larmore posed that are calculable and supported by her calculations. Now, we didn't want to waste your time by calling Mr. Kirkendall in. She testified exactly what Mr. Kirkendall said, had criticisms of. We agreed. Dr. Larmore, I have no issue with her or her testimony. We're not disputing most of what she said, so I wasn't going to waste your time by calling Mr. Kirkendall in and making you listen to numbers for another hour. Okay? But one of the calculations that Dr. Larmore posed was not supported, and that's that loss of earnings category for Anne Marie.
Let's see here, and as you sit here today, are you aware of any medical professional that has testified either in deposition or during this trial that Mrs. Echevarria is unable to return to work?
I'm not aware of any.
But her remaining calculations, loss of household services, loss of probable support, we don't take issue with those numbers. Okay, so I want to walk through what those numbers actually mean with your verdict form. Okay, because of the way your verdict form is set out between past and future damages, and because Dr. Larmore's calculations apply to both Eric and Anne Marie, here's what I'd like you to do. The loss of probable support in the past, meaning from the date of the accident to today, Dr. Larimore calculated out, could you go back to that slide, please? Dr. Larimore calculated out to $210,000 total. Loss of household services from the date of the accident to us standing here in this room, we're rounding it up to $55,000. Those are for the past damages. Those total $265,000. We want you to divide that in half and place it on the two lines. If we could go to that slide, please. Place it onto the two lines, A and C. You see from the date of the incident to the present, from the date of the incident to the present, 132,000, 132,000. Now, Dr. Larimore calculated out the future damages for these same categories. And they actually came out to be right about the same. $375,000 for future loss of probable support, meaning Eric Sr.'s wages, and $375,000 for the loss of household services by Eric. So again, this total is for both Anne Marie and Eric. That total is $750,000. Divide that in two, put it on the verdict form. That's going to be B and D. Experience in the future, experience in the future. Those are those calculable damages. The other calculable damages that we have in this case are the medical bills and funeral costs. We're not disputing those. You heard no testimony, no argument from us. Those are undisputed. You can put those onto the verdict form. Now, here's where it gets tricky. Pain and suffering damages. So let's talk about those. You have an instruction in your packet that you may not use sympathy as a guide. We know, if we could flip to the next slide, we know that we cannot bring, what is the next slide? Okay. We know that we cannot bring Eric back. What plaintiffs are asking you for, $35 million. It's above and beyond reasonable. We want you to stay reasonable. And I want to give you a perspective on, do I have the pain? I'm sorry. Go ahead. Okay, so what I'd like to do before I get to that slide, and I apologize. What I'd like to do is talk about, again, past pain and suffering for both Anne Marie and Eric. That is from the date of the accident to the present. $100,000 for a total of $232,000 for past damages. That is what we are suggesting. Future damages. We are suggesting that you take those loss of household services and loss of probable support, and you award each Eric and Anne Marie $800,000 apiece. That is the number we are suggesting, 1.175. $1,175,000 for Anne Marie, $1,175,000 for Eric Jr. Now you heard plaintiff state, you're not supposed to have sympathy. We agree, you're not. It's hard. It's one of the hardest things you're going to have to do in this trial that you've been selected for. You're not supposed to have sympathy for either party. That includes Eric, that includes Zaon. Plaintiffs have asked you for an exorbitant sum. I want to put that money into perspective. We've created a cartoon image. Oh, sorry. Let me pause here. Go back to that one. Total damages after we add up all the numbers I just gave you. $2,922,146.92. $2.9 million. Okay, so plaintiffs have asked you for that exorbitant sum of money. I want to put that into perspective. This is a cartoon animation of $50,000.
Objection, Your Honor.
Same objection as before.
Prejudicial, same objections as before.
Okay, I've already made a ruling on it. Overruled.
Thank you.
This is a cartoon image of $50,000. And if we take that animation and we give you a picture of what $35 million would look like, this is what it would look like.
Same objection, Your Honor.
Overruled pursuant to what I said before,
Thank you.
and the limitations of how it should be presented.
$35 million is what they're seeking. Let's put that into further perspective.
Yeah, same objection, Your Honor, for this.
Same rulings as before.
Thank you, Your Honor.
Eric Senior would have to work for 583 years to get to $35 million if he didn't spend a dime. Person could buy 70 homes for $500 a piece. Could pay for 350 all-inclusive around the world trips for $100,000 a piece. Now plaintiff wants you to award $35 million as a matter of principle. We're not here, ladies and gentlemen, on a matter of principle. We're here to compensate this family. We're not here to take a stand, to send a message. We are here because we have an accident in which two drivers share some responsibility. A man has died, and we're here to determine reasonable compensation. That is your job. That is your job in this lawsuit. So your job is to fairly and neutrally assess the percentages of negligence between the drivers. We have two drivers who made mistakes. We're asking that you check no on that box on punitive damages because there is not clear and convincing evidence out of the mouth of their own expert. And we're asking that any other damages that you feel are warranted remain reasonable. Remember the value of that dollar and compensate this family, not go beyond the pale on damages on principle. That's not what we're here to do. You did not see that instruction in your packet because that's not your job. This is a case about responsibilities for mistakes, not vengeance, not extending a criminal punishment somebody is unhappy about. Your duty is to follow the law that's set forth in those packets, ladies and gentlemen. And I ask again, please remember, are we a community of vengeance or are we a community of fairness and forgiveness? Thank you.
Okay, Mr. Johnson.
Thank you, everyone. I want to start by thanking court, Judge Albertson, staff, the marshal, plaintiff's counsel, and my co-counsel and my client, and of course you, the weeks that you spent here in your consideration of this case. Last time I had an opportunity to speak with you a long time was in the opening. And the opening is what gives the attorneys the opportunity to tell you what they think the evidence is going to show. And you'll hear, for anyone who paid that much attention to my opening, that my opening is going to be very similar to my closing, because what we believe the evidence was going to show was shown. My partner and I, Mr. Watson, we had the good fortune to represent Marvin Collins in a deeply emotional case. It's true. We promised to show you, however, that Mr. Collins did not cause Mr. Echevarria's death, and we believe that the evidence would show that this was a terrible accident and not the product of anything that he did directly. Now, in their opening, they said, as it relates to Mr. Collins,
Objection relevance, Your Honor. The negligent entrustment has been dismissed. We're on the NRS 41.141.
I can comment on what was said in their opening, Your Honor, whether or not they proved it or not.
Ken, but I just want to be clear, like, we are all on the same page that this is not a continuing claim, right?
Correct, Your Honor.
Yes,
Trust has been dismissed. It's only the
at
I
the
mean,
close,
what's the intention of council approach? Okay, council, go ahead.
in the opening, we have to respond to what they believe the evidence is going to show. Plaintiffs said that they were not suing Marvin because he was Zaon's father, but because Marvin entrusted his muscle car to a son who he knew had a history of excessive speeding and reckless driving. I think we have a part of that plaintiff's opening statement.
Marvin Collins is Zaon's father, but we're not suing him because he's his father. We're suing Marvin Collins because he was the owner of the vehicle. He was the owner of that gray Dodge Challenger. What you'll hear is that he entrusted Zaon Collins with a powerful muscle car when Zaon Collins had a history of excessive speeding and reckless driving.
That's why they said they were suing my client in their opening. Not because he was his father, but that he entrusted that car to his son, who he knew had a history of excessive speeding and reckless driving. So we, in our opening, stated, we believe that the facts will show those allegations to be false, that he simply allowed his son to drive his car on occasion. He didn't live with his son lived with his mother, that he was driving for the purpose of the loan. He was going to go to basketball practice. The speeding tickets didn't have anything to do with his car, and he was unaware of it. So his entrustment of the vehicle was not negligent. Now, in closing, we were right. He did not negligently entrust his car. Now, they have dismissed that case. Now, they're suing him because he is his father. And because he is his father and allowed his son to drive his car, he's going to be vicariously negligent, as if he was driving it himself. Now, there is a jury instruction on that. That's jury instruction number 27. Don't have to take my word for it. Can you pull that up, Hunter? And if you can't, that's okay. I've got it here. Everyone get jury instructions? It's 27. That's cool. Let's just roll with it. Zaon is the son, first line. Marvin is the owner of the car, and he's the parent. That's 27. That's not negligent entrustment. That's not a negligent entrustment. Just simply he's being sued because he is the father. Now, that's the law. I'm not asking you not to follow the law, but that wasn't what was promised in the opening. Was another issue that we brought up in the opening. In our opening, we tried to value your time and get to the point. We're saying we anticipate they're going to be asking questions about damages, and they're maybe asking for a big number, and to watch that because we believe some of those damages are not supportable. And we specifically reference the thing in one instance, they're seeking $250,000 wage claim that we felt was not going to be supported by competent evidence. And we were right. You pull up Dr. Laramore's testimony. That's the economist.
Doctor, what is the weakest part of your opinion as it relates to Mrs. Echevarria's lost wage claim?
I'm assuming,
You're assuming,
the assumption that she's unable to return to work.
right, that's a big weakness in your opinion, because you're having to assume, correct? Because you were not presented any medical records to review that would support her position that she can no longer work, correct? You weren't presented any psychological reports saying that her anxiety and depressions prevent her from working, right? Those are the types of things that you typically rely on when you form opinions regarding whether or not someone can work when you make your lost wage calculations. Is that not correct?
If that information is available,
And isn't it typically available in your reports?
not always, sometimes we're asked to make assumptions.
Well, what percentage of your cases are you asked to make an assumption on someone's ability to work is based solely on that person saying they can?
I don't even know, I could guess.
It'd be a small percentage, would you agree?
It's not common.
So we were right on that. Actually, the trustment were correct. We came through. That aspect of the loss, the damage claim, we are correct. And I wasn't even sure if it was broken out on their damages up there about that lost wage claim, but that's not correct. And I think that we proved that. But where this case is, we're just kind of nibbling around the edges. Because the third thing that we believe the evidence was going to show was related to liability, related to fault. And we got in front of you and we stated that that Mr. Collins had the right to challenge the accusation that his son was responsible for the accident, because we believe that evidence would be presented that although, remember, this is an opening, Zaon was speeding, driving clearly an excessive speed, which we stated in opening at the time of the accident, but there were other factors. We believe the evidence is going to show there was a straightaway. Over 10 miles of visibility. We said that in the opening. Mr. Echevarria, on the other hand, had to yield to oncoming traffic, whether they were at the speed limit or not. And it would be undisputed that Mr. Echevarria attempted to cross in front of Zaon, who had the right of way.
Objection cumulative with our counsel's arguments, Your Honor.
And respond.
Overruled.
Thank you, Your Honor. And we proved it. But you don't have to take our word for it, because we took it right out of the mouths of their witnesses. The road was clear and straight and unobstructed, was it not? Can you play Mr. Terry's testimony?
This incident occurred at 3:23 p.m., correct?
I believe that's right. Yes, it was an afternoon, 3:23, correct.
It was a bright sunny day.
Yes, ma'am.
The roads were dry, straight, and level.
That's my impression, yes.
I believe you indicated that the weather data indicated there was over 10 miles of visibility. Is that right?
Correct.
Now that's important because you have to look at the facts of this accident. This obviously wasn't an accident where Mr. Echevarria was struck from behind, or Mr. Echevarria was attempting to get across two lanes of traffic where he had to look left, then right, and then when he pulled out, he hit. It wasn't at night. It wasn't at dusk. He wasn't confused by headlights. He wasn't distracted by any type of crazy signs. There's no evidence of that. It wasn't rainy. Wasn't foggy. The conditions were clear, open, and he had an unobstructed view of the traffic coming towards him. That's what we believe the evidence show, and that's what it showed. Also in the opening, I asked that you look carefully at that video. Now, we can talk all we want about what the video shows. Y'all can look at the video as well as anybody else, and you can see how the accident happened and who was driving, where they were driving, who pulled out, who didn't, who took evasive action. It'd be offensive to me to tell you to look through my eyes. It's something you can look at it yourself. And I said in the opening, you'll be interested to look at that video because it lays it all out. Additionally, we believe that based upon those facts that I just stated that we've proven, that they would attempt to deflect by claiming that, well, Mr. Echevarria must have been confused by the speed. He was going so fast somehow he couldn't judge the speed. But unfortunately for them, their own expert, Mr. Terry, contradicted that argument. Can you play Mr. Terry's testimony at 207?
Drivers have an obligation to act reasonably on the road, correct?
I would agree with that.
Okay. If a driver cannot reasonably determine the speed of a vehicle that's approaching, the reasonable decision would to be more, not less cautious in crossing that lane of traffic. True?
Again, depending on the location of the vehicle, it's may not necessarily be legal safe, but yes, generally, I agree with that.
I mean, the less information you have as a driver, the more cautious you should be. True?
That's fair.
So again, if you could see him and there was any question, who had the ability to be more cautious? According to Mr. Terry, Mr. Echevarria. That was established. They claimed that Zaon was impaired. I'm not going to go through all the impairment stuff Ms. Zinna aptly displayed, but however, despite the lack of a charge for impairment and much less a conviction, somebody asked a question that caused this don't know the speeds into question. Can you play Mr. Terry's testimony on 227?
Based on the data provided, did Zaon brake aggressively or just slowly braked?
It was a full ABS lock, so it was an aggressive braking maneuver.
An impaired driver locked up the brakes when he saw that person pulling in front of him. He saw it. That's not impairment. That's someone watching the road, driving at excessive speed, granted, which we've already said, but that's inconsistent. All the circumstantial evidence of impairment, is it not? Immediately lock up the brakes. It wasn't, hey, and just drive right into somebody, which might be the impression some of y'all got in an opening. They brought in a toxicologist to bolster, we believe, the impairment argument. But he made it very clear, the toxicologist, Dr. Kelly, that he's not an accident reconstructionist, right? And he failed to realize he basically destroyed the impaired driver theory. Could you play Dr. Kelly, please?
Do you have any general understanding of how fast a driver is supposed to react to a roadway obstruction?
I do.
What's that?
1.5 seconds on the average.
Okay. And so in the event that there was a 0.7-second gap between the vehicle entering the roadway and the brakes being applied, that'd be within normal reaction, correct?
True.
Those are the facts in this case. Dr. Kelly said the average person takes a 1.5 seconds to react to that type of driving. The other expert came in and said that Zaon, the impaired driver, reacted in 0.78 seconds. You don't need a calculator. That's half the time of an average person's reaction time. Is that the sign of an impaired driver to you? So we believe they've got a very weak impaired driver theory, and there's clear comparative fault because Mr. Echevarria pulled out based upon all those factors we went through. And then they went back to Mr. Terry again to wrap it all up. And at that point, Mr. Terry, we believe, but what's important is whether you believe, lost all credibility with the next theory. Do you mind playing that, please?
All right, well, then I just want to go ahead and talk to you about some things you actually have formulated some opinions on. I want to make sure I got them correct. You testified just moments ago, and tell me if I'm wrong, that a driver traveling straight on a roadway has the right of way over someone making a left-hand turn across oncoming traffic. Is that true?
So I don't think we did discuss that, but yes, that's generally true, correct.
Okay. And so who had the right of way in the collision that you prepared opinions for today?
On approach, Mr. Collins would have the right of way.
But it's your opinion, that you stated previously that Mr. Collins, Zaon Collins, bears the responsibility of this collision.
That's also correct.
Okay. I just want to make sure the jury fully appreciates your position. It's your opinion that the driver with the right of way is 100% at fault for this collision, and the driver who failed to yield the right of way has no responsibility. Is that correct?
That's a summary, yes.
Zaon had the right of way, but he's at fault, according to Mr. Terry. We wanted to lay that out. But of course, there was not a jury instruction read to you that says speeding means you no longer have the right of way. If any such law existed, you better believe it would be in that bundle sitting on your lap. The reason is simple, is that a driver needs to yield the right of way even if oncoming traffic is speeding. Can we go to jury instruction 29, please? You don't have it, that's cool. This is that legal cause and substantial factor, which can be confusing when you look at the jury instructions. The legal cause of injury is a cause that is a substantial factor about bringing back that injury. Cutting in front of somebody, knowing you shouldn't cut in front of them, or not paying attention, or whatever your issues are as a driver, is a legal cause that can cause a substantial factor bringing about the injury. Then it drops. The substantial factor is causing harm is a factor the reasonable person would consider to be contributed to the harm. Mr. Echevarria was the legal cause of the injury because his harm was a substantial factor because a reasonable person would consider it to have contributed to the harm. He's at fault. We're going to ask you to apportion that fault, but that's what that means, and that's what the evidence showed. Now, Mr. Terry doesn't agree, and you have to gauge his credibility. And when engaging that credibility, remember who Mr. Terry is. Everyone comes here with their own baggage. I believe he testified. He's testified from Mr. Ladah's office 20 times since 2015. 30% of his business is with Mr. Ladah's office. And 100% of the defendants in those cases are found to be at fault by Mr. Terry. Something to consider when one is considering believability and credibility. If we look at jury instruction number 36. This must be an important instruction because all three attorneys talked about it. It's the duty when someone makes a left-hand turn. There is enforced at time of the occurrence a law which reads as follows: the driver of a vehicle within an intersection intending to turn left shall yield the right of way.
Council approach, please.
Instruction 36.
This is clearly cumulative still.
Council, we talked about this, so
Wrap it up, Your Honor.
thank you.
On 36, it says, or so close thereto to constitute an immediate hazard. Saw the video. That's close enough to constitute immediate hazard and yield the right of way. Also, can't leave without talking about Mr. Terry one more time, realizing how silly you had the right of way, but you're at fault. He tried to recover, but he made it worse. Could you show Mr. Terry's testimony at 208, lines 2 through 12?
Review, was there anything that was blocking Mr. Echevarria's view of oncoming traffic?
I don't believe so.
Is there anything that would have prevented him from taking an extra moment to have a meaningful look at oncoming traffic?
Not that I'm aware of, no.
And if Mr. Echevarria had allowed the Dodge in question to pass before he entered the intersection, this collision would not have occurred. True?
Any decision to affect the timing, where he arrives before or after, could avoid it, yes, correct.
Obey the rules of the road and prevent the accident from occurring. That's their expert. Now, they moved on to eyewitness Robin Lee. You guys, I was not here that day, but you can gauge her credibility. Appears as though after reviewing her testimony, she wanted to be the star witness, but forgot that she told the investigating officers that her view was blocked. Gave a lot of testimony, but told the investigators my view was blocked behind a car. You'll have to gauge that credibility. There's also discussion, I believe there was something up there about, you have to look at all the evidence. There was a discussion with Miss Echevarria right after the accident, really heartbreaking. But you had to listen to what she said. And she had said who she was speaking to.
Objection cumulative, Your Honor.
I'll move on.
Thank you.
But that's not a premonition.
I make an objection, it's all cumulative. This is prejudicial to plaintiff, Your Honor. I ask that his entire argument be stricken because it's identical to prior counsels.
Not identical. I have a client.
How much longer do you have?
I have 1 minute, Your Honor.
Okay, go ahead and finish up, please.
Let me end by acknowledging the undeniable tragedy which is at the heart of this lawsuit. A life was lost, and nothing can diminish that sorrow of that fact, something we said in the opening. But this trial is not about sympathy, it's about facts, truth, and justice. Reverse engineering damages like they did, here's 35,000, you guys go back and add up to it, doesn't give you much guidance. We're asked to speak the unvarnished truth during voir dire. Let's consider the challenge that was issued to you in opening. And that is the safety rules. Could you play plaintiff's opening, please? 53.
What brings us all to Park County Courthouse here today are the driving safety rules that protect us all from serious injury and death on our roadways. Like all safety rules, these safety rules will protect us only if juries choose to enforce them.
Are you going to enforce them on both parties? Because if you do, I'm confident that you will find that my client was not responsible for this accident, but more likely than not, it's Mr. Echevarria. Thank you.
Okay, at this time, we're gonna take an afternoon break. And I'm just gonna let you guys know, like, this will be your last break before we go to deliberation. So when you come back, you're gonna get final words from counsel. And then we're gonna go to deliberation. So with that being said, I'm gonna read you your instruction. You're instructed not to talk with each other with anyone else about any subject or issue connected with this trial. You're not to read, watch, or listen to any report or commentary on the trial by any person connected with the case or by any medium of information, including without limitation, newspapers, television, the internet, or radio. You're not to conduct any research on your own relating to this case, such as consulting dictionaries, using the internet, using reference materials. You're not to conduct any investigation, test any theory of the case, recreate an aspect of the case, or in any other way investigate or learn about the case on your own. You're not to talk with others, text others, tweet others, Google issues, or conduct any other kind of book or computer research with regard to any issue, party, witness, or attorney involved in this case. You're not to form or express any opinion on any subject connected with this trial until the case is finally submitted to you. Okay, with that being said, you're gonna get a 15-minute break now, and then, like I said, plan for when you come back. You're just gonna hear the rebuttal argument from plaintiff's counsel and go to deliberation. So we will see you at let's say 3:30. Try to be back by 3:30. I think want to make any additional record at this time before we take a break.
Just a quick record, Your Honor, that
The door's closed.
that both counsel were cumulative. They even showed the same clips, the same videos, made the same arguments on the same jury instructions. It was identical. They shouldn't be allowed to make the same arguments. I object to cumulative. At this time, I ask that the counsel for Marvin Collins' entire argument be stricken, Your Honor, because it's inappropriate, it's prejudicial, and it shouldn't have been allowed.
Okay, response.
Yes, Your Honor. That's outrageous in this particular case that Mr. Collins has a right to a defense, and the fact he's not on the jury verdict, he's on the caption of this case. They have attempted somewhat successfully to curb my ability to represent Mr. Collins by claiming that pointing out the weaknesses that overlap with their entire case in front of the jury somehow prejudices them. And I guess according to them, I couldn't argue that this jury should find that Mr. Echevarria was 51% responsible for the accident because lo and behold, my guy isn't on the jury verdict, and giving a contrary opinion as to value would be inappropriate. And that's impacted my ability to represent Mr. Collins. So for that reason, I'd ask that the request be stricken.
The request be stricken. Okay. Okay. Go ahead with the response. I'm assuming Ms. Zinna, you don't have a dog in this fight, right? So you're fine?
I join Mr. Johnson's objection.
Okay,
For response.
go ahead.
At this point, there's no independent, separate liability to Mr. Collins. It's a derivative action, and this, at that point, is based on vicarious liability. No different than in the incident where an employee is being sued and the company's being sued. So at this point, his whole argument is inappropriate. My understanding, he was gonna get there, up there and make this distinction, make different arguments, and he made exactly the same arguments, even showed exactly the same clips, Your Honor. I think it should be stricken.
Want to say anything more?
Well, I did make the same arguments, didn't show the same clips. Just because we have the same witnesses, et cetera. What I should have been able to do is argue that Mr. Echevarria is barred by bringing this claim. And I guess because it's a derivative claim now, that I couldn't do so. And that was the objection. Somehow this was going to be, I just have to ride piggyback on Marvin's case, or excuse me, on Zaon's case. And it's not true.
Well, okay, wait. You should have made the argument that Ms. Echevarria couldn't bring her case at all. Is that what you're saying?
Sorry.
What did you just say about Ms. Echevarria not being able to bring her case at all? Did I hear you correctly? Okay,
That I wouldn't have the ability to bring a case on behalf of Marvin at all if I misspoke
Yeah.
at all.
okay. The case, your position and your clients, the claims against your client were not the same when we started this trial. Okay, there was a negligent entrustment claim against your client when we started this trial. There is no longer a negligent entrustment claim. There is just now the 41440 claim, which is the family purpose doctrine. And we now have a verdict form with only Zaon's name on it. And I was willing to, and we discussed this in the beginning, how this was all going to work. But like I said, the case was in a different position in the beginning of this trial than it is now. So throughout the trial, you were allowed to ask questions of all the witnesses separate from Ms. Zinna. You were allowed to call your own witnesses separate from Ms. Zinna because of the way the case started. However, about midway through, maybe a third of the way through your closing argument, Mr. Ladah made the objection that you were, and we discussed that nothing was going to be cumulative as well. I don't know if you were the one on the phone when we did that, or on the part of the conversation, or if it was is it your partner, the other gentleman, Mr. Watson? I don't know if it was you or your partner, but we discussed that we were going to avoid cumulative work. And that was an agreement even when the case was in the position it was in previously. But now in the position the case is in, Mr. Ladah made the objection about a third of the way through your closing that this was cumulative. Now, I was willing to allow a certain amount because yes, I believe your client does have a right to a defense as well. However, now the case is in, for you to essentially be able to come in and give the same arguments that should be given. I think the equivalent situation would be if we allowed both plaintiffs' counsel to get up and give closings, because Mr. Ladah said, well, I represent Miss Echevarria, and Mr. Chu said, well, I represent Eric Jr. And there's no way you guys would allow that over there. I mean, am I correct?
They certainly could have.
Oh, you would have no. They would.
They wanted to knock themselves out, but I was prevented from making those arguments. I represent a different party.
Okay.
Has different theories on what the liability is on this case, and different ways to communicate what we believe
Okay.
liability is. And I should be able to present that to represent my client because he's the one who's going to be on the financial hook on this case.
What were you not
That's
allowed
big-
to say? Because I let you go on and on and on quite a while, and well past Mr. Ladah's objection. I only called you guys up here when it just became so obvious. It was the same arguments that Ms. Zinna was making, just a different way of making them.
Your Honor, that makes a different way. That's part of a different presentation. So I don't. They brought in my client.
Mm-hmm.
And they put on their case, and that unraveled before them. And now they will want me, after having all these defenses I can present to the jury specifically to my client, somebody just want me to sit over here like a potted plant.
Okay, but you didn't have to do that. You got to get up and give your closing, right?
I had to do it. I had to give a closing.
Okay, yes, but I'm asking you, was there some part of your closing you were precluded from giving, as we sit here right now?
Yes.
Which part?
I was cut off on going through jury instructions. I was cut off in terms of what I could suggest would be a
Well, make your
return.
record now. What would you have said that
I
you
would have
think
said,
you were cut off?
Had not been cut off, that Mr. Echevarria was at least 51% responsible for this accident.
Ms. Zena already said that
No,
on
she didn't.
behalf.
She said 50%.
Okay.
51%.
Fine.
So wasn't gonna have a whole jump up and a heart attack. Now he's arguing something different.
Okay.
Because I was prevented from doing that. I was prevented from going in and discussing in detail what I felt were other jury instructions. For instance, we didn't get into jury instructions related to my interpretation of 28 or my discussions of
Okay.
certainly 36. And that was the one on the
Okay, you wanted to
39.
discuss 8. I think Miss Zena hit on that. You wanted to discuss 4. About me?
Excuse me?
You wanted to discuss 4, saying that you thought that I did something to express favoritism to one side or the other?
Discuss 27, 28, 29, and 36. And the special verdict form.
27, you're not precluded from discussing. That's 41,440. I'm not sure what part of any ruling that you thought you were precluded from discussing 27.
Because it was
Okay.
that it was going to be redundant. That only counsel can talk about jury instructions.
No.
I never
Come
said
on.
only one counsel could talk about jury instruction.
No.
There was all,
Yeah,
basically, I was being told that I was just.
You want to talk about 41,440 and you feel like you haven't had the opportunity to do that.
Sure, I want to get.
What do you want to say
that.
about 41,440?
If that's the jury instruction.
What were you
yes.
prepared to say about it? That's what I'm asking you right now. What were you curtailed from saying?
And what stopped you from saying
What
it?
jury instruction is it, John? If I get it.
You just said it.
Hey, only comes from the peanut gallery. I'm talking to the judge.
You're the one who just told me that you were
Right.
precluded from talking about instruction 27, 41440.
Exactly. I didn't say 441. I was going to get up and get into detail about
Okay.
what the statute covered.
Okay,
I got-
is it your position that doesn't cover, that your client doesn't fall under Zaon through this
But I
statute?
wanted to explain it to them and why he was being sued. and
Okay,
What basis it was.
You
And
think they don't
what they said
understand?
They were gonna be, what they said they were gonna be able to prove, and no. That's one example.
you already said that. You did get to that. You did get to that. And you did make it clear that they brought a negligent trustman claim and that wasn't a viable claim. That was at least from what I heard, that was very clearly made. And you actually, and look, this is the first time I've actually ever seen people pull clips of attorneys talking in opening for part of their closing. I thought it was an interesting way of doing it, but you did pull him from his opening and put video from his opening and put it out there. So you made that point, but if you feel like you haven't had a chance to make that point, do you want the chance to make that point when they come back in?
I want to make that, be able to argue to this jury that Mr. Echevarria is 51% responsible for this accident. That's why.
Okay, but how is that not the same argument that Ms. Zinna should have made?
Because 51% is a total bar of that claim. 50% is half. That's what I want to get. And I had to lead up to that point by going over all of these things that they claim are redundant, because I needed that.
I asked you how much longer you had and you said 1 minute. You didn't tell me I have 5 more minutes because I need to make the 51%. So I'm honestly like, I'm having a little bit of trouble. Go ahead, just keep going. Go ahead.
That's what I want to argue. I was prevented from doing that because my understanding from the court ruling is that everything I was doing up here is redundant. And I guess going over what we feel.
No, my ruling was very clear. Do not do redundant stuff.
Right.
Okay,
Going
but if
over-
your position is the 51 wasn't redundant, then you could have done that. And I said, how much more, counsel, when he tried to get me to completely cut you off because he said it's cumulative.
John, what am I gonna say when you're agreeing that it's cumulative and I'm gonna get my argument short circuited? Give me a minute to wrap it up. But if I go up there and I'm going to say what I believe the breakout is on comparative fault, that's going to be redundant and run contrary to your rulings. And I don't want to do that. I believe that I, on behalf of my client, can look at that same facts, argue to the jury, and come up with a different breakout on the comparative fault.
Okay.
Can I make a record, Your Honor?
You're gonna get to respond.
Thank you.
Yeah, go ahead.
Okay, this is the
Hold on,
problem.
I just wanna make sure. That's everything, right?
Yes, Your Honor. Thank you.
Okay, go for it.
Okay, this is the problem, Your Honor. So, I understand you made the ruling earlier that they can't be cumulative. I'm not sure if Mr. Johnson was here or if it was his partner.
It doesn't really matter because knowledge has to be imputed to them. If they made a choice to do that, knowledge is imputed from one to the other. So that ruling imputes from one to the other. They
Sure.
should both understand it. Go ahead.
And then I asked Mr. Johnson how long his closing was gonna be. He said 15 minutes, maybe 20 minutes tops. He was not 15 to 20 minutes, he was longer. So I made the objection early on that it was cumulative when he started making exactly the same arguments and showing exactly the same clips as prior counsel. At the bench, my understanding is your issue was with the cumulative, there was no problem with him making different arguments or separate arguments or other arguments that prior counsel had not already made. And you weren't trying to rush him from making different arguments or dissimilar arguments than prior counsel. So if he had dissimilar arguments or other arguments, all you needed to do was hear the court. I understood your ruling pretty clear that you can make other arguments, you can say whatever you want as long as it's not cumulative. And instead of doing that, he got up and started making the same arguments, cumulative, identical arguments again, over and over again. So the issue here is not that he wasn't given the opportunity. The objection, my understanding is the objection wasn't even sustained. You were just cautioning him to make different arguments, make sure they're not cumulative arguments. And instead of making different arguments, not make cumulative arguments, he got back up and started making exactly the same arguments. So he didn't even listen to the court's caution. And now he's claiming he didn't get the opportunity to make these different arguments, but he could have made the different arguments because you weren't precluding him from making different arguments. So I think this is all a sham to try to create a record that doesn't exist on an appellate issue that doesn't exist because he had his opportunity. So I don't think there's anything inappropriate here. I think it's all fair game. And I think all of those arguments were cumulative, quite frankly, Your Honor. So I just want to make a record on that.
Go ahead, Ms. Johnson.
What the record is going to show is that I was curtailed from making an argument. And I'm not saying court is wrong. I just disagree. I disagree with counsel's ironically circular reasoning that he's just gone over this long. This part of the case has taken longer than my very truncated closing. That being said, I want to be able to get in front of the jury. They come back in and make my position. I don't care if it's derivative or not, that the comparative fault here is 51%, but I don't want to run afoul of the court.
What are you asking for?
I want to be able to make that argument. According to them, it's cumulative when I make the argument, but when I don't make the argument, it's not. I want to be able to get up there and say, based upon the evidence, Mr. Echevarria is more responsible for this accident than that of Zaon. And I want to pull up the redundant jury verdict form and put 51% down from Mr. Echevarria. That's what I want to do. And that would be my offer of proof that the court doesn't. Thank you.
How long are you asking for that?
However long it was for me to say that, Your Honor. I mean, it's difficult. 3 minutes?
You're asking for
Nice.
2 minutes.
2 minutes.
Judge, when we were up in the bench, our
I
objection,
thought I was very clear, and
you were
I
very
do
clear,
feel
Judge.
like you guys understood me, but I also think maybe it's a convenient misunderstanding right now, Mr. Johnson, and I'm a little bit alarmed by that. However, I am taking you for your word that you did not understand, but my intent was not to curtail your argument. It was to prevent you and ask you to please stop making cumulative arguments. I didn't see you bringing up anything that wasn't almost exactly piggybacking on Ms. Zinna's, just filling in where you thought there were gaps. And that's not a fair situation, because the only way for me to make that fair would be if I said to the other side too, you know what, you two can both do the same thing. And then they got up to give two closings too, because there's 2 clients over there too. It's not, but they have the same interests, and your clients now have the same interests. So we're not in the same situation we were when the case first started, okay? We're in the situation where I'm not sure there's a conflict here for your clients even to be for these 2 defendants to even be represented by the same people anymore. And frankly, as you know, they weren't represented by somebody different until very late. So I'm not sure that there was ever belief that there was a conflict there early on.
Well, without divulging, I know the court is asking.
No, don't give me any attorney.
I appreciate for believing from a fellow officer of the court on what was stated. I can make references, the representation of this court. This isn't something I'm just thinking of now. But what, at one hand, we're calling filling in the gaps. They're claiming it's cumulative. But I have a closing where the verdict form was already filled out before any of this came up.
Where's your filled out verdict form?
Again,
Where's your filled out verdict form? Let me see it.
am I pulling up?
It's part of your, you have a PowerPoint with a filled out verdict form for him? Okay. No, I'm looking at your IT person. Okay, so you have a filled out verdict form. Okay. Okay, so you had a closing with a filled out verdict form. Go ahead. Sure.
Yes. Drop down. That's what's. But I want to file. That's why I didn't press it.
Your Honor, this is the problem. He needs to make the offer of proof during his argument. So if there's an objection and the court cautions him, he can't wait till he's done, say, I'm done, and then come back and say, oh, well, I wanted to do more. There's other things I wanted to do, and then try to create a record after the fact. And first of all, no offense against defense counsel. I'm not trying to throw stones at him, but I don't believe your instruction at the bench was ambiguous in any way, shape, or form. I think it was very clear. You said over and over again, you can't do cumulative things. If you want to do something different, make different arguments, you can do that, but you can't make cumulative arguments. That's why when he started making the cumulative arguments over and over again, I objected again, and it sounded like the court was cautioning him again, but you didn't prevent him. You didn't prevent him from making a different argument. If he had wanted to make a different argument, all he had to do was put that on the screen, wait for an objection, and then Your Honor could rule on the objection at that time. He can't now come back and say, oh, I want to do this. Oh, I want to do that. Oh, I want to do all these other things. This is a false record he's trying to create here. He needed to do this contemporaneous with his closing at the time. He can't do it after he says he's done. That's improper. He hasn't created a proper record on it, and it's improper for him to try to do it now because he didn't do it contemporaneous when he was in his closing.
What's your response?
I made a record. Did I put this up and do an offer of proof in front of the jury? No. Court said, how much longer do you have to have? Need to move on, and you said wrap that business up as related to that particular jury instruction on the yield. When I went up there to wrap it up, just like you asked me to, there was another objection.
So, but why at no point did you then say I'm getting to this and then get to the different point?
It was going to be redundant, that going, oh.
Okay, you've seen the form. Here's what we're gonna do. I'm not gonna continue to go back and forth on this. You can have literally 3 minutes, okay, to get up and put that form up there. You put it up now, they get to see it. They get to know your argument. That's it. We're gonna take a break right now. When we come back from the break, that's what you're gonna do. I'm taking you at your word, counsel, that you misunderstood my instruction. However, I do not think I was unclear, okay? I was very clear with you that the redundant part, the repetitive part was what wasn't gonna be okay, okay? And by the way, if you smirk when I'm having this conversation with you, I'm gonna think you're lying. So continue to smirk and I'm not gonna believe what you're saying, okay? That's the impression that it's giving, okay? So if you are telling the truth, please do not do that, okay? I'm giving you 3 minutes to get up and put your form up there. That's it. We're not playing some crazy game right now, okay? That's it. Now, you're gonna get to do your rebuttal afterwards. I'm gonna give a 5-minute break right now because I need a break too for a minute. And you're gonna literally get 3 minutes to get up and do that. That's it.
Thanks, Your Honor.
Understood? We're back on A21-844-4652C. We're outside the presence of the jury. We just have counsel present. Go ahead.
Your Honor, this is a serious issue. And I think it's implicating ethical issues as well. I don't believe Mr. Johnson misunderstood the court's ruling at the bench, Your Honor. I think it's clear that he understood. I think whatever happened, either he got distracted from the objection and forgot to put up his verdict form, but either way, he didn't try to put up the verdict form. Your Honor never precluded him from putting up the verdict form. This is tantamount to someone resting and then saying, oh, I forgot to do something, I want to do something else, and creating a false record, making something up to try to get back on up there and try to make new arguments that they forgot to make. This is prejudicial, this is inequitable, this is unfair, this should not be allowed, Your Honor.
So you don't think he's being truthful with
I
me?
do not. I do not.
Okay.
I'm sorry. I don't like to throw stones at council, but I have to say, I do not believe he's being truthful.
Okay. I want you to respond.
Yeah.
Let me make sure he's finished. Do you have anything else to say before I let him respond? So I'll let you speak again at the end because you're the moving party right now.
No, Your Honor.
Okay, go ahead, Mr. Johnson.
You know, Your Honor, it's funny that someone who doesn't want to cast stones lives in a glass house.
Okay, okay,
And
go ahead.
my honesty with the court. Do I have to debase myself and show you special verdict form and my notes? Show you that I have the special verdict form lined up as a slide, my grand total of 8 slides that I forgot to bring it up? No, it was my understanding that based on the court's ruling, that for me to go into the verdict form would be redundant because counsel already did it and that my client's not on the verdict form, so why should I care? It's basically my interpretation of that.
Here was the issue, and this is why I believe Mr. Ladah objected in the beginning. You were arguing all the same stuff Ms. Zinna argued. And we had already had a discussion about how this was gonna work at trial before the negligent entrustment claim even went away, but it honestly got worse after the negligent entrustment claim went away. We just didn't have a second discussion about abiling cumulative work.
I understand all that, Your Honor, but that's a far cry from saying that I knew that I'm lying to you. I'm not smirking at that. What is that? What do I have to gain or lose here? My 33 years of reputation in this legal community, which is above reproach. I have to look it up. I'm in here defending a guy who's up against $35 million claim against him. I should be able to address the verdict form. But because I obviously respect this court, I'm not going to bring it up after you just told me that's redundant and that my guy isn't on the verdict form. So why would I be able to even talk about the verdict form? That's why I didn't bring it up. Maybe Mr. Ladah forgets things like that. I don't. It's clear. And I presented it to you. And I appreciate the court takes things with a grain of salt. And you said, show me the slide. Are you going to call my bluff? That would have been, I would be a liar, right, Your Honor? And he pulled it right up. And at that point in time, yeah, I smirked.
Well, I'll be honest, I didn't know what to believe at that moment because frankly, I'd asked you when you were sitting up there, how much more do you have, counsel? And you said 1 minute. And then you did your 1 minute and you sat down.
Based upon what you had told me. I don't believe I was going to be able to do that. It would be in violation of your rule because it would be redundant on what Ms. Zinna did. She pulled up the same jury verdict form, but I think the evidence shows something different than that, not 50, but 51. That's the whole point.
Okay, do you guys want to say anything else?
Yeah, just briefly, Your Honor. Your Honor asked defense counsel at the bench conference, based on my recollection, what else he had to do. What additional arguments he had. Does he have anything other than cumulative? He never once mentioned the verdict form. He never once said, I'm going to show the verdict form. So perhaps he had the verdict form prepared in advance, but the problem is he didn't try to show it after the objection. That's the issue here. It's not whether or not he had it prepared in advance. It's that he needs to actually show it.
I understand the issue from your side, I think, but here's the thing. If he's limited to just showing what he showed on that slide, and you're prepared for that now, and you've even had a couple minutes to adjust your rebuttal, how are you harmed by that?
We are harmed because he has now been given the opportunity to think about what he forgot to show the jury.
Well, he's going to be very limited to just what you understand the limitation, Mr. Johnson, correct? That it's essentially because you were asked, what did you not do that you wanted to do that wasn't cumulative? And when you sat down here and you said, oh, well, I had a verdict form prepared and I was going to argue 51-49. Okay, so that's your limitation there. You get to argue 51-49 for a very brief period at this point, and you don't get to revisit all the same arguments Ms. Zinna said all over again. Okay, when you started going through the instructions like that, it was one after another, many of which she had already pointed out. This almost the exact same way. And the point is not so that you get 2 bites at the apple here. Okay, you understand? So I'm going to let him do it. You're prepared for it. You can see what he does. If he goes beyond what we've talked about, you will be limited. And then they get to get up and do their rebuttal. Okay. Okay, any questions? Anybody else want to make an additional record? And I understand your concerns, Mr. Ladah. I obviously have some too, which some of the stuff I voiced as well. Okay, I don't know you well enough to know what's in your head. Maybe you're a nervous laugher. I don't know. But at the same time, like I said, like some of this behavior is a little bit alarming. I'm taking you at your word that you said that you misunderstood my ruling. But at the same time, like the correct step, if you misunderstand any more rulings, is I don't understand what you're saying, Judge. Can you please detail that further? Okay, because there's very little room to actually remedy these things as we move forward. Understood?
Thank you, Your Honor.
Okay, bring him in.
Okay, thank you. The council acknowledge the presence of the jury.
Yes, Your Honor.
Okay. Thank you very much, ladies and gentlemen, for coming back so quickly and promptly. We're just gonna get right into it. As I said, when I gave you the break, that's your last break of the day. We do expect to be able to get this case to you for deliberations today, and we're working very hard to do that. Mr. Johnson, go ahead.
Thank you, Your Honor. You're asked to speak the unvarnished truth during voir dire. I'm going to speak the unvarnished truth in closing. Go ahead and pull up the special jury verdict form. This is the form that you'll be looking at. You find by preponderance of the evidence Zaon Collins was negligent. Yeah, he was. He was traveling too fast. Go ahead. Whoa, back up. Just click the first box, please. Can you do that? You find preponderance that his negligence was a legal cause. Yes, he was speeding. Check the box. The next one, you find by a preponderance of evidence that Eric was negligent. Yes, he was. Go to number 4. You find for preponderance of evidence that his negligence was a legal cause. We went through that. Yes, it was. The question here is, what is the percentage? Using 100% of the total combined, the person who had the last chance to avoid this accident had all the facts in front of him and did not have the right of way was Zaon Collins. So however you want to break that out, he could not have more than 49% responsibility for that accident. Whereas Eric, who had all the information in front of him, knew the car was coming on a clear record and knew he had to yield the right of way, according to the rules of the road, the unvarnished truth would be 51%. And then you can put whatever numbers you feel as important as it relates to the damages. I'm not going to repeat that. And if you do that, I'm confident that your decision will be one based upon the facts in this case. And I appreciate your time in that regard.
Thank you. Okay, rebuttal from plaintiff's counsel.
All right. Am I on here? Good afternoon, everyone. I'm the last voice you get to hear before you get to go back and deliberate. I echo the sentiment of my colleagues, thanking you for your time and your patience and your attention. By nature, rebuttal jumps around a bit. I'm going to be addressing things that were brought up by the defense in their closings. So bear with me, all right? Really quickly, why we did not talk about Marvin Collins and the negligent entrustment claim in closing today, and why we didn't really pursue evidence of that after a certain point of our 2-week trial. As you heard, there was a ruling by the court about the family purpose doctrine, NRS 41.440. You have an instruction on it. Once that ruling came down, any liability attributable to Zaon Collins is imputed to Marvin Collins. We no longer need to prove the negligent entrustment. All right, there's no tricks, there's no games. All right, so there was a lot of bluster about us not proving that part of our claim. If we were trying to do so today, we would have been wasting more of your time. I want to be very clear about something, okay? And we're going to walk through this law. There's good lawyers over there, but they're misstating facts, and surprisingly, they're really misstating law. A couple of very important ones. And the first one is this left turn law, all right? We're gonna look closer at this instruction, which is number 36, but I just want to throw a question out there that I'm having a hard time with, which is at what point would the defendants concede that Zaon was fully to blame based on his speed? How fast would he have to have been going? Where would they draw the line? What if he was going 100 or 125 or 150? Would that have been enough? At what point would they have given in and agreed with the statement that you heard on the body-worn camera video, which is in evidence, where the police explained to Zaon on the day of the crash that, well, when you're traveling that far in excess of the speed limit, you forfeit your right of way. He was going 2.5 times. Would it be 3 times? 5 times? So the truth is they don't have a line, all right? What they're trying to get up and convince you is that no matter how fast the car going straight through an intersection is traveling, that car will always have an unconditional right of way, no matter what. No matter how fast they're going, how hard it is for the yielding cars on the road to see them or to judge their speeds or their gap distances, the car going straight is always going to have the right of way. It doesn't matter if it's an F1 car going 190 miles an hour. That's what they want you to believe here. This is contrary to Nevada law. It's contrary to the instruction you've been given. Joe, can you please pull up instruction 36? So I want to point something out, and I could point there, but it's kind of awkward that my back's to half of you guys. If our lawmakers wanted the right of way to be unconditional, under no circumstances can the car going straight give up their right of way. They would have stopped the sentence right here. The driver of a vehicle within an intersection intending to turn to the left shall yield the right of way to any vehicle approaching from the opposite direction, period. Full stop. Okay? They didn't do that. They included all this additional language that you see there. They did that to account for situations just like this one, okay? So the law says that drivers in Eric's position, yes, they have to yield the right of way to oncoming cars that are already in the intersection or so close thereto so as to constitute an immediate hazard. That's the quote, and that's fair, that's appropriate. No dispute from us on that. But when the oncoming vehicle is speeding so egregiously fast, 2.5 times, more than 2.5 times the speed limit, that 80 to 82% of the motoring public, including Eric and including Robin Lee, could not reasonably perceive that car to be an immediate hazard. And on that basis, they begin to make their left turn. The excessively speeding car forfeits their right of way to the left turning vehicle. That's exactly what happened here, all right? The defense is acting like this additional language in the statute doesn't exist. Sure, it doesn't use the language forfeit right of way. This is the law, okay? This is the law that's being referred to by the officer in the hospital. This is the law that was violated because Zaon Collins gave up his right of way when he decided not to go 10 over, not 20 over, not 30 over, not even 50 over the 35-mile-an-hour speed limit, all right? 88 in a 35. If someone is traveling north of 2.5 times the speed limit, they can't be perceived as an immediate hazard by a law-abiding motorist waiting with his signal on in that left turn lane. The car flying through the intersection gives up his right of way. It's that simple. And I want to go back. Joe, can you please pull up? I don't need the whole Sam Terry clip, but just the clip, the still shot of the neighbor's camera where it shows the cars going down towards the crash. And you don't need to play it. What Sam Terry told you was that this median here, if everyone can see, this median, the length of this median, okay, 280 feet, all right? And the distance from the end of this median to just right here where the crash occurs was double that. Double that. So they can say, oh, you can see it with your own eyes, as if the angle doesn't matter. But guess what? They never got up there and poked holes in Sam Terry's distance measurements. They certainly didn't get their own expert to do it, and they didn't do it through cross-examining him. Okay, that is unrebutted expert testimony. More than double the distance of 280 feet, just that little section at the top. And Joe, pull up Exhibit 72, please. It's in evidence. And this starts to make more sense when we consider the fact that when Mr. Echevarria, Eric Sr., began his left turn, again, this part hasn't been impeached, or there's been no successful holes poked in it either. This time was 2.5 seconds, okay? 2.5 seconds is when Mr. Echevarria started to make his left turn, meaning he had already decided to. He said he decided to at 3.5. At 2.5, he's already turning into the intersection. At that moment, when Zaon's going 87 miles an hour, okay, he's not even at his top speed yet. Look how far away he is from the crash site. 275.6 feet. He's darn near a football field away. So what they're asking you to do is say that when an oncoming car is nearly a football field away, that he should be perceived as an immediate hazard such that you should know not to begin an otherwise completely lawful left turn. I want to put 88 and a 35 in perspective, okay? It was really downplayed in the closing arguments that we heard from the defense, all right? This is like going 63 in a 25-mile-an-hour residential neighborhood. Imagine that. This is the equivalent of going 162 miles an hour on a 65-mile-per-hour freeway. 88 and 35 isn't just speeding, folks. It is flying. It's reckless, it's dangerous, and you don't get to blame others for being at fault when a wreck is caused when you're going 88 and a 35. So the left turn law actually demonstrates that Zaon gave up his right of way. Read it over for yourselves. Look at the evidence. All right. Now, I was surprised to hear an argument in the first closing that, well, they both took these evasive maneuvers, right? Zaon swerves to the right and Eric speeds up, and that Zaon's was proper and expected, and no one testified that Eric's was proper. Okay, so here we go. Let's blame Eric more. Think about what they're arguing for a second. All right. As Detective Figueroa testified, the Hyundai's event recorder shows that in the last millisecond before the crash, Eric anticipated the crash coming. He hit the gas in a last-ditch attempt to get out of the way of what was essentially a missile coming towards him, all right? And what they're arguing is that Eric, upon realizing in that last millisecond that the challenger's coming right at him, he should have just stayed in place. He should have just stayed there. He should have anticipated that Zaon was going to swerve to the right at the last moment. So in order to avoid the collision, he needed to stay there, however unnatural that might have felt with the car barreling down on him at 88 miles an hour, okay? We'll just have faith that he's going to swerve around me. And he should have processed all this in the span of, 0.1 seconds. They're arguing that even though the challenger is bearing directly toward him at this frightening rate of speed that he sees at the very last second, the reasonable thing to do for Eric would have just been to hold still. And then they can't place you at least as much at fault as they are. All right. And they say that there's no evidence that Eric's evasive maneuver was improper. Well, we have Sam Terry, who testified that there was nothing improper about the way Eric executed his left turn, not in terms of speed or angle or whatever else. We have Detective Figueroa, who testified unambiguously it was Zaon's speed that was the cause of the crash. Okay. And we have Robin Lee, who said that she herself would have turned to, and we're going to talk about those folks in a little bit, but I want to maintain some semblance of an order here. I'm sorry if I don't. All right, let's talk about Eric was on his phone. All right, let's get this out of the way. So there's actually two videos where Anne Marie talks about being on the phone with Eric. Joe, do you have the other one? Can you play the other one that wasn't played?
Okay, you know what, he's, oh,
You know, and it's hard to tell, you know, we're honest about that. It sounds like I tried to call him and he went to Wendy's. You know, in the other video, she's talking about it was earlier. Let's really think about this, okay? Over the past 2+ weeks now, you've heard endless talk about police records, police findings, investigation by different units within Metro. You've seen a bunch of the hundreds of photographs, all of which are in evidence from crime scene analysts. You've seen body-worn camera clips from several different officers in several locations. Those are in evidence too. You can look at them. You heard, I don't know, was it 2.5 hours or so of testimony from Fatal Details lead detective assigned to the crash, Detective Figueroa. In short, all of the police evidence has played a big part in this case. Amidst all this, what did you not hear a single time, all right? What were you never shown? You were never shown a record, a single reference to a police report. You didn't hear any statements from any of the police investigating on the scene. You didn't hear any testimony from police who appeared at trial that even vaguely suggests that Eric was on the phone when this crash happened. This wasn't some little cursory investigation like, you know, following a rear end or a fender bender. Detective Figueroa's supplemental report alone was 35 pages, all right? If Eric or any of the parties, frankly, were on their phones at the time of this crash, this would have been established or at least mentioned in the mountain of police evidence that was discussed and presented to you in this case. This would have been detailed, documented, and if confirmed, actual evidence of this fact would have been enthusiastically reported to you by defense counsel. If Eric was on the phone, surely they would have asked Detective Figueroa to confirm this fact at some point during his 2.5 hours of testimony. That didn't happen. They decided not to ask him that question, even though he's the lead detective who oversaw this entire investigation, every little detail. And they look into whether you're on your phone when you get a speeding ticket. You don't think that was done here? Purely for the sake of argument, though, let's consider, let's look at their theory a little bit more, okay? To make their argument stick, they have to prove, one, Eric was indeed on his phone, all right, which they don't, or they haven't, but for now, let's just assume he was. 2, if Eric was proved to be on his phone, they'd have to prove that he wasn't using Bluetooth, because if he was, in which I dare say it's overwhelmingly common these days amongst modern phones and modern vehicles, the norm, if you will. But in any event, if he was using Bluetooth, that would undercut the whole notion that using the phone was wrong or problematic. There's nothing improper or illegal about talking on your phone if you're on Bluetooth. And even then, if they prove that Eric was both on the phone and not using Bluetooth, again, we're just making multiple concessions here that we don't need to, but even then, they would still have to prove that being on the phone actually caused him to drive unsafely or caused him to do something wrong. And there's no evidence of that here. Again, we have Sam Terry giving statistical peer-reviewed data accepted within the field of accident reconstruction. This isn't his own data, where he said that 80 to 82% of drivers would have made that exact same turn in that exact same situation, and that the turn he made was normal. Detective Figueroa is saying it was Zaon's speed that was the cause of the crash, and Robin Lee, right behind where Eric was, saying she would have gone too when Zaon came out of nowhere like a meteor. The phone is a non-starter. Really, either way you land with it, all right? It's immaterial. In legal circles, I don't know if I should be proud to admit I run in those, but in legal circles, we often refer to this type of thing as a red herring, okay? They want to dangle something shiny and pretty immaterial over here, hoping to distract you from this evidence that really hurts them over here, okay? And that evidence, it's no surprise, is 88 and a 35 with an illegal amount of THC in the system, all right? They want to throw things against the wall and hope they stick. And it's really not the only thing that it's not the only Hail Mary they throw, okay? I'm not gonna go into all of them, but there's a few others, right? Like, did anyone catch the question of Detective Figueroa about, oh, you're from New York too, right? Oh, do you know the Echevarria family's from New York, as if somehow he was gonna alter his investigation, a 20-year veteran of the force because they're both from New York. Maybe I was the only one who picked up on that. Or this thing about how the Challenger, it was just the base version. It wasn't the souped up version. It was just a regular car. We're reaching here. And look, it's understandable that you have to use these type of tactics when you have to defend the case that they have to defend. 88 and a 35 with an illegal amount of weed in the system is tough. Let's talk about Robin Lee for a second, all right? I was surprised that we really heard anything about her in the closing arguments, but we did. You know what she testified to. She wasn't surprised when Eric started his turn. From her vantage point, the coast looked completely clear. She, in fact, said she was getting ready to make that same turn herself when the Challenger came in out of nowhere. She testified to these things in trial. She said the same thing to the police back then. They have no choice but to try to discredit her. Saying she wanted to be the star of the show when she came in here under the circumstances that she described, I think is a little unfair, but to each his own. And counsel said, I wrote it down because I want to be accurate, that Robin Lee told police that her view was blocked by the car in front of her. So just because people say things, just because there's words that come out of mouths doesn't make them true, all right? That's why we give you the evidence. The video of Robin Lee talking to police is one of the videos in evidence. You can take a look at it. They showed you part of it in their closing, but maybe not the part that wouldn't be too favorable for them. She absolutely never told the police that her view was blocked such that she couldn't see what was in front of her. She did talk about this blind spot thing, all right? And as she repeatedly told police, because she said he came out of nowhere, she never said my view was blocked in such a way that I couldn't see what was coming. As she explained in her testimony here, she had about a 90% field of vision, that she stops her car far enough behind the cars that are in front of her to leave herself a good field of vision. It's an open area, and that she could clearly see the 1, 2, 3 cars that passed by in the opposite direction of Fort Apache and went through the intersection, but she could not see the Challenger. The Challenger came out of nowhere. And that's why she thought the coast was completely clear. That's why she would have turned too. That's why she says she felt like she touched death that day. Because if she had been first in line where Eric was positioned, she would have made that left turn and that would have been her on the wall. But let's discredit her and call her the lady who wants to be the star of the show. Keep in mind, she's not on team plaintiff. She's not on team defendant. She has no dog in this fight, Robin Lee. You need to think about that when you evaluate the credibility of her testimony and the weight of her testimony. She wasn't paid to be here. She gains nothing from this lawsuit. She didn't know Anne Marie or Eric or Zaon for that matter before this crash, and she doesn't know them now. She's not playing favorites. She has no motivation to come in here and be untruthful. I dare say that if you are remotely on the fence about any aspect of who's at fault in this crash, and I don't think you should be, but as jurors, we respect whatever opinion you have, but if that's the case, Robin Lee is your tiebreaker. She is a neutral voice. The coast was completely clear, and she's part of that 80 to 82% that the data shows of drivers who would have made that same turn, as was Eric, tragically. All right. I'm going to move on to impairment. There's a couple other things, but I think we can try to shortcut this. I apologize. I don't mean to wax on and off too long here. I said there were multiple misstatements of law made by defense counsel in their closings. I'm going to get to the second really big one in a moment, but as a precursor, let's recap quickly the evidence for and against impairment. All right. So the evidence that Zaon was not impaired at the time of the crash. All right. We have the video clip of police on the scene as they showed you saying no signs of impairment. You have that video and evidence for yourselves. That was determined after a 32-second assessment of Zaon in the back of the ambulance involving only the follow my pen with your eyes test. Okay. That was it. You can look at that evidence for yourself if you want. And then we have Zaon's own word, okay, claiming he wasn't impaired. What evidence do we have for impairment? We have a much longer and more comprehensive field sobriety test done at the hospital. The test was still only partial. They couldn't test his balance or things like that because he was in the hospital bed getting medical treatment. But it was a lot longer than 32 seconds. And this was the only field sobriety test that was actually documented. You heard Dr. Kelly talk about that, about how this was documented by 2 different officers who confirmed the same findings. We then have Dr. Kelly's unrebutted expert opinion that to a reasonable degree of scientific probability, Zaon used marijuana in one form or another 0 to 6.5 hours before the crash, and that he was impaired and that the impairment interfered with his ability to safely drive that day. And then we have the extensive scientific studies and literature that Dr. Kelly cited, people with various levels of THC in their system, some higher than Zaon, some lower than Zaon, are 2.7 times more likely to get into a wreck. That's their fault. And then we have the driving behaviors of Zaon that day. I heard a comment that Zaon immediately hit the brakes. Eric started his turn at 2.5 seconds. The data shows that Zaon started to brake at about 1.6, 1.7 seconds, nearly a full second gap in there. You can be the judge of whether that is a quick reaction time. But we think the evidence is clear that in totality, he was impaired and that was a factor in the crash. But let me be very clear about something. We don't have to prove impairment. No part of our case against the defendants relies on our ability to prove impairment. Proving Zaon was at fault for the crash doesn't require us to prove impairment. Proving that the crash was the legal cause of Eric's death doesn't require us to show impairment. And the amount of damages suffered by my clients is not impacted by our ability to prove impairment in the slightest. Go ahead and read through your instructions when you get back to the deliberation room and look at the instructions on negligence and causation and plaintiff's damages. There's nothing in there about us having to prove impairment. But here's where that misstatement of law came in, all right? Joe, can you show page 2 of the verdict form real quick? As you know, yes, thank you. You know what? Sir, as you know, down. Thank you. Down. Come on. No more. Okay. Right here. Hey, nope. Oh, yeah, I'm sorry. Very down here, Joe. All right. You have to answer this question. It's the last question you're going to answer after filling in everything else. Does the jury find by clear and convincing evidence that punitive damages should be assessed? Defense counsel told you that for you to check that box yes and impose punitive damages against Zaon Collins, that we had to show by a preponderance of the evidence that Zaon Collins was impaired. Okay. Joe, can you pull up instruction 37, please? Now? Okay, go up to the top, I'm sorry. So neither of those claims is true, okay? We don't have to prove impairment by any standard, clear and convincing or otherwise. And we don't have to, our ability to have you evaluate the evidence and check the box yes for punitive damages does not depend on us showing impairment at all, again, by either standard. So The first part of this instruction cites Nevada law. All right. It is unlawful for any person to drive or be in actual physical control of a vehicle on a highway or on a premises to which the public has access with an amount of any of the following prohibited substances in his or her blood that is equal or greater to than, and you know the data, the numbers, the standards. Now please scroll down, Joe. All right. So we then have to prove item 1 and item 2. I want to focus on item 2 first because it's easy. All right. Defendant Zaon Collins thereafter caused actual harm to the plaintiff by operating a motor vehicle in violation of NRS 484C110. NRS 484C110 is the top part of the page. It is the per se, it is the legal limit for marijuana while operating a motor vehicle in the state of Nevada. It is 2 nanograms per milliliter for the THC and 5 for the marijuana metabolite. And as Dr. Kelly testified to, it is not an opinion, it is a fact that he was in excess of both of those thresholds. Both of them. Okay, so he's in violation of NRS 484C110 because when he was operating a motor vehicle, he was above those legal limits. The first part of that second sentence, thereafter caused actual harm to the plaintiff. I don't think that's in dispute. I don't think anyone from that table would dispute it either. There was harm caused to the plaintiff by virtue of the fact that he passed away in this crash while Zaon Collins was driving a motor vehicle over the legal thresholds that are outlined in that statute, okay? So number 2 is easy. But for us to have you check the box for punitive damages, we still need to prove number 1, all right? And what you decide on this particular question is all going to come down to one word. It's going to come down to willfully, all right? Willfully. What you have to ask yourself is, whatever marijuana Zaon consumed, which caused his blood to test in excess of the legal limits an hour and a half after the crash, did he use that marijuana willfully? Now, he tells us the only time in his entire life that he used marijuana before the crash was 2 to 4 days earlier when a friend whose name he doesn't know or doesn't remember gave him a couple gummies that, unbeknownst to Zaon, were actually weed gummies. We had Dr. Kelly come in here, and I don't need to go over his full resume with you, but I submit that he's quite qualified, arguably overqualified. And he looked at all the evidence in this case. He gave us a number of opinions, and he said that the blood draw results were flatly inconsistent with someone who last use of marijuana was 2 gummies 2 to 4 days ago. And instead it was consistent with use 0 to 6.5 hours earlier. We don't need to replay that video. So if Zaon used marijuana the same day of the crash, as Dr. Kelly believes, and as the science indicates, and as the toxicology literature indicates, then he's not telling us about it. And I submit to you it was willful. But if you ignore the science, if you ignore Dr. Kelly's opinions, and you believe that Zaon's last weed use was indeed 2 to 4 days prior to the crash, you have to evaluate the credibility of his claim that when he ate those 2 gummies at the party on the previous weekend, he did so without knowing they were marijuana gummies. All right, and to evaluate Zaon's credibility on this particular subject, we have to look at different statements he's made when he's been questioned about marijuana. In this case, both in deposition and at trial, he has told us right hand before God that when he went to the party, he had never used marijuana once in his life, and he ate these 2 gummies unaware that they contained weed in them. Yet, a couple hours after the crash, he was asked by Metro officers if he uses weed. We're going to play the video again, but just to be clear, you have this video back there. If you think that we are misrepresenting what's being stated, watch it 2, 3, 4 or 5 times, 10 times, turn it up as loud as you want to. The questions go like this. Do you smoke cigarettes? No. You drink alcohol? No. Well, occasionally. Any weed? Occasionally. Joe, can you play it, please?
I'm Oscar Powell, okay? We're gonna be doing an investigation, all right? So, right now, we're gonna be checking, starting a permit. You smoke marijuana today? I don't know. What did you drink today? You smoke weed today?
You're good, go. So this begs the question, okay? Why would someone tell police they are an occasional weed user if the only weed they ever used in their entire life was one occasion when the use was completely unintentional? Why would you tell police it was occasionally? Why wouldn't you just say I used it one time in my life, but it was completely unknowing? So whatever marijuana was in his system at the time of the crash, you have to decide based on his credibility and whatever else you want to consider, whether he used that willfully. And if you believe there's clear and convincing evidence that Zaon's last use, whenever it was willful, then it's appropriate to assess punitive damages. Notice that nowhere on that entire page, I'm getting too pointer happy, nowhere on that entire page, and it's instruction 37, does it talk about impairment? Okay, it does not talk about impairment. We do not have to prove impairment for any reason to any standard. We think the evidence shows he was impaired and that impairment was a factor in this crash based on a number of things that I'm not going to bore you with by going over again. But no part of our case, including this punitive damages assessment, depends on us proving impairment. And if there's any concern, because I know Zaon talked about how he doesn't remember being at the hospital. He doesn't remember even anything from the scene. The only thing he remembers is going over to check on Mr. Eric. And, you know, we already played you the clip from Miss Lee where she says she was watching that whole time and she saw nothing like that. She did not see him go check on Mr. Eric. But in either event, Zaon said he didn't remember anything from being at the hospital. And, you know, he got into this accident, and if you might be wondering, well, was there an injury or was there a head injury or anything like that? I submit to you that there is no evidence of any type that at any point Zaon was complaining of a headache or a feeling like he couldn't remember things, or he was getting treatment at the hospital for his wrist. You won't see any treatment.
An objection, Your Honor, this is not an evidence.
It's in the, he's being treated for his wrist in the body cam video. That's an evidence. That's fine. I'm talking about the evidence. I'm only talking about the evidence and what's not in there.
Okay, guys.
I'll move on, Judge. I mean, but I disagree that I was misstating anything.
Is it in the video that's in evidence?
What's in the video is him getting treatment for his wrist and him not getting any treatment for or complaining of injuries.
It's in the
to his
video.
head.
The video's been in evidence, isn't it?
It is the one I'm referring to.
The video is body cam footage, it's not medical.
Okay, are you gonna move on, or do you want, do I
I'm-
need to make a ruling? I'm
All
okay
done.
either way, but just let me know.
I moved on.
Okay, thank you very much.
Another thing you don't see in the video footage in the hospital, nothing to do with anything medical. And there's a lot of interaction between Eric and the police officers. A lot of talk about how the crash happened and, you know, this guy pulled in front of me and all answering questions from police. What you will not see or not hear if you watch all this footage, and again, I'm not asking you to take my word for it. You can do it if you want. At no point in all that footage is there a question posed by Zaon, hey, is the other guy okay? What's going on with the other guy? Is he all right? What's his condition? Draw your own conclusions about that. I'm about done. I just want to touch on one or two quick items. So we are not asking for damages in this case based on this idea that, well, it can buy this many $100,000 cruises around the world, or this many $500,000 homes. That is not the basis of our damages requests. And frankly, it cheapens the severity of the damages that were suffered by this family. They're not based on Eric's salary, not based on vacations. The defense keeps using this word reasonable. They want you to be reasonable, reasonable, reasonable when talking about damages. Eric Jr., when he was on the witness stand, you may or may not remember this. I asked him how often does he think about his dad? And he said something I wasn't expecting. He said, mostly in the mornings. And I asked him to explain why, without any idea what he was going to say, which kind of breaks the cardinal rule of lawyering. And what he explained was because he has these brief moments of time when he wakes up in the mornings. Could be really short, sometimes might be a little bit longer, but in this brief pocket of time when he wakes up in the mornings, he doesn't realize that his dad is gone. He's not thinking about the fact that his dad died. And every morning, maybe after 5 seconds or 30 seconds or a minute, he comes to the realization that his dad isn't here anymore. What is reasonable in terms of damages for that pain, that emptiness that Eric Jr. feels? Are we going to quantify that by the number of around the world cruises it can buy? What's the reasonable, Joe, can I see the picture please of Jr.? What is the reasonable amount of damages for Eric Jr.? Having his heart broken every time he hangs out with his friends and he sees his friends interact with their dads. And he knows that when he goes home, his dad's not going to be there. What's the reasonable amount of damages to fill that void? They want to measure Eric Sr.'s salary as a basis for, the Eric Sr. would have had to work whatever it was, 500 and some odd times to equate to the figure that the plaintiffs are asking for in this case. You know, it's funny that they brought that up. Because if you recall, especially when Eric Jr. is not here because he's in finals, Eric Jr. talking about how important his education was to his dad, Eric Sr. Because Eric Sr. would tell him things like, you got to get good grades so you don't end up with a job like mine. Humble, gracious. That type of guidance, that type of mentorship, that type of influence from a father to a son ripped away. What's the reasonable amount of damages to compensate for that? Joe, show me the picture of Eric and Marie, please. Anne-Marie. Eric and Anne-Marie. I mean, their love wasn't real. Look what kind of couple takes a picture in front of a collage of pictures of themselves. My goodness. What's the reasonable amount of damages to award a woman who kisses her husband goodbye in the morning, goes through her day, and the next time she sees him, he's naked on a gurney, deformed and disfigured and deceased. And that's the next time she sees him. What are the reasonable damages for that type of pain, for that type of shock? $88 and a $35. When you look at the verdict form, Joe, I'm sorry, go back to the verdict form, please. Under question 6, please. You see things under 6A. These are real categories of damages, right? These are real things you can account for. Grief, sorrow, loss of companionship, loss of comfort. These weren't buzzwords that Mr. Ladah was using to pull on heartstrings. This is the law on what is compensable for wrongful death in this state. And these are real things that Anne Marie and Eric Jr. experienced when their father, their husband, the centerpiece of their home and their lives was erased off the planet because of 88 and a 35. Any one of these categories, you could reasonably write in 10, 15, $20 million. That's a big number to think about, but these damages are big. These damages are incomparable to the number of round the world cruises that can be bought. Shallow. The number that Mr. Ladah asked for and which I'm asking you for, humbly, but vehemently, is a reasonable figure. Really appreciate your guys' time and attention these past couple weeks. Thank you, Judge.
Thank you. Okay. At this time, I have one final instruction to read you, and then we're going to swear in my marshal. So you're about to enter deliberations. During deliberations, other than deliberating with each other in the deliberation room, jurors are not to, 1, communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. 2, read, watch, or listen to any news or media accounts or commentary about the case. 3, do any research such as consulting dictionaries, using the internet, or using any reference materials. 4, make any investigation, test any theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own. Okay, with that being said, Kim, can you swear in Greg? And I know Jill's on her way out to be sworn in as well.
You do solemnly swear that you will keep these alternate jurors. Sorry. You do solemnly swear that you will keep these jurors together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself unless it be by order of the court, except to ask them whether they agree upon a verdict, and that you will return them into court when they have so agreed. Swear that you will keep these alternate jurors in a private and convenient place, that you will not permit any person to speak to them unless it is so ordered by the court.
Okay, ladies and gentlemen of the jury, I will now tell you that in this trial, our alternate jurors are Mr. Christopher Rooks and Thomas Fava. Okay, I'm going to ask the alternates to please follow my JA. She's going to walk you outside and give you some alternate instructions. Okay, if I don't see you again, thank you very much for your service. Okay, then they'll come back in. Okay, if I don't see you again, thank you very much for your service. But until we've been notified that the remaining jurors have reached a verdict, you're still obligated not to discuss this case with anybody. We will notify you if and when we need you back, or when the jury has reached a verdict. Okay, do you want to swear them in right now? Okay, so I just need you guys to stand and raise your right hand, please, and then right after you're sworn in, you're going to walk out with Jill.
You do solemnly swear that if called upon to serve as a juror, you will well and truly try this case at issue, according to the evidence, so help you God.
Go ahead and follow Jill, and she'll give you some additional instructions outside. Okay, I will now ask the rest of the jurors to please go with the marshal to the jury deliberation room. He will bring in all of the exhibits, which will be admitted together with the verdict forms, and you may take your instructions and your notebooks with you. So please feel free to take all of your items with you. Door's closed, right? Okay, so at this time, everybody can please be seated. Plaintiffs' counsel, do you want to make any kind of record of anything at this time?
No, you are.
Okay, defense counsel, do you want to make any kind of record at this time? Okay, before we go on break, I want to make a brief comment. To the parties in here. I want to thank you for your behavior toward each other throughout this trial. You've had to sit here less than 3 feet apart from each other, through some very emotional stuff. And I want you to understand too, that at no time did I forget that there are people on both sides of this whose lives have been forever changed. So thank you for your behavior throughout this trial. Thank you for being courteous with one another. And I really appreciate how you've been with one another, especially in light of the fact that it could not have been easy sitting this close to each other for this long. So with that being said, if nobody has any additional record to make, I'm just going to ask counsel for your phone numbers, please. And we will call you if there is a question or if they return with a verdict. You are also welcome to stay in the courtroom until at least 5 o'clock. At 5 o'clock, if you are in the courtroom and if I have all counsel in here, we'll have a discussion as to whether or not the jurors, sometimes they do come and ask if they can leave. And if they've made that request, I will bring it to you. But otherwise, our normal procedure in here is to let them deliberate until they come and ask us if they get to go home for the evening. So,
No matter how late, Judge?
well, we haven't tried that yet. So I do not know how far that's gonna push. But I don't think we've had anybody past 6 or so before they've come in and asked if they can leave for dinner. And if they come in and leave, if they ask us and it's after 6, I'm gonna call you guys in and basically tell you that they asked and give them the instruction that allows them to come back tomorrow and deliberate. Okay, so any other questions or any other concerns? Okay, so with that being said, we are off the record and we can break until they come back. Please come up and everybody can be seated. To counsel acknowledge the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
Okay, so what is my understanding? You've requested to go home for the evening, come back tomorrow. I have to just read you one instruction and then I can go ahead and release you. And it is my understanding you'll be back at 10 o'clock tomorrow. That's the consensus, right? Okay. So although you have begun deliberations, you're not to continue deliberating or discussing the case, and you're not to form or express any additional opinions on any subject connected with this trial until you're all back together in the deliberation room. The time to return tomorrow is 10 o'clock. So please wait for everybody to be there before you start deliberating. So if someone's a few minutes late, you wait for everybody to be there before you start deliberating. Thank you very much, ladies and gentlemen. You are released for the evening at this time. And the instruction that stands, that I have to read to you every time we take a break, still stands with the exception of now you're in deliberation. So you're instructed not to talk with each other, with anyone else about a subject or issue connected with this trial. You're not to read, watch, or listen to any report or commentary on the trial by any person connected with the case or by medium of information, including without limitation, newspaper, television, or the internet, or radio. You're not to conduct any research on your own relating to this case, such as consulting dictionaries, using the internet, or using any reference materials. You're not to conduct any investigation, test any theory of the case, recreate an aspect of the case, or in any other way learn about the case on your own. You're not to talk with others, text others, tweet others, Google issues, or conduct any other kind of book or computer research with regard to any issue, party, witness, or attorney involved in the case. You're not to form or express any opinion on any subject connected with this trial until you're back in the jury deliberation room tomorrow at 10 o'clock with everybody there. Thank you very much. You are released for the evening. So if everybody could please be seated. Tomorrow, I'm going to tell you about my schedule first, and then let's talk about process after they come back. I do have hearings tomorrow morning at 9:45 and 11 o'clock. I believe I probably will be done around 11:30, 11:45. If they get back or if they return a verdict sometime in the midst there, we will call you and have you guys come back and we'll read it and go through the process. I also have hearings in the afternoon tomorrow, but obviously if they're back, I will reschedule that hearing. With that being said, I do have a verdict form that you all proposed if this thing goes to punitives, but I do not have a actual appropriate instruction. So did you discuss appropriate instructions if this goes to punitives? And am I correct that this verdict form I received, that's a very simple verdict form that simply just has one line, is the verdict form that council have agreed to if this goes to punitives?
Yes, Your Honor.
I believe so, Your Honor. I'll have to double check it.
Okay, you can come up and look if you want and see what I'm holding. You're welcome to look, and same with you, Mr. Johnson.
I'll let I'm on the human damage. Board.
You can take it back if you want. I've
Yeah,
got more
I
copies
think
of it.
that's
That
right.
is right. That is correct.
Yes.
Do you want to see it or are you sure that?
That's the one I prepared, Your Honor.
Okay. Okay, so I have the one punitive verdict form, and then what about instructions?
I believe there's only one instruction, but I would like to look over that tonight just to make sure if that's okay.
Yeah, why don't you communicate with one another? What do people expect to do? If they come back with that mark checked, are you just going right to an additional closing argument, or are you going to want to put somebody on the stand? If so, who?
I would only want to call Mr. Collins, Mr. Zaon Collins onto the stand. That's it.
Okay. And defense, do you want to put anybody on?
Yes, potentially, Your Honor, in addition to Zaon, but let me give that some thought, please.
Okay, I do want you to give each other as much notice as possible, so when can you let opposing counsel know? It's not as important by tomorrow morning. It's not as important you let me know as much as you let them know. So by tomorrow morning, you'll send them an email like by 9 o'clock?
Yeah.
Okay, with anybody else they want, and if you all want anybody in addition to Zaon, you will let them know by 9 o'clock tomorrow morning as well, right?
Yes, sir.
Okay, anything else we need to discuss? I actually, maybe it'd be a good idea whether they're back or not. Unless you all are fully in agreement with the form and any additional instructions and any witnesses, unless you're fully in agreement, maybe it'll be a good idea for you all to come to my 11 o'clock calendar as well. Maybe at 11:30, and we just make a record of everything. I'll call you last. So if you want to show up around 11:30, that would be good, and we'll just confirm on the record any additional instructions, the verdict form, and any witnesses. Anybody have any problem with that, or is everybody available tomorrow, 11:30?
No problem, guys.
But you don't need us at 10 when the jury gets here, correct?
No, they go back, and I mean, they might call sooner than 11:30, and if they do, we'll call you guys right away. But yeah, if they call sooner than that, but I think 11:30 is probably fine, unless they're just super quick. Full disclosure too, at least one of them who's in the group was good chunk of time late today, and she blamed it on EDC traffic. So hopefully that won't be a problem tomorrow, but they're not even allowed to start deliberating until everybody's back in the room. So they might not all be there immediately. And if they don't all show up, like if I hear that they're not all there by like 10:30, I will contact you guys and ask you to come sooner to figure out if we're gonna replace with one of the alternates or what we're gonna do. Okay, so it doesn't get further delayed, because we at least made the deal with one juror that she wasn't gonna be here on the 23rd. So I would like to see this over by the 23rd, and I don't see any reason why it can't be at this time. Does anybody feel otherwise, like there's a chance this might go past the 22nd?
No chance.
I would be shocked, John.
Okay, thank you very much, counsel. Yes,
And I attend that 11:30 tomorrow remotely.
remote is fine. That goes for everybody. If you all want to jump on remote, it's fine. Just, if everybody's remote, file the jury instructions and the verdict form and anything else that you want to deal with in the case, so we know. Otherwise, you can come in person and just hand it to me.
And to be clear, punitive damages does not implicate Mr. Johnson's client.
Okay, so I don't know if you even want to be, I mean, you're welcome to be a part of it. You're not excluded, but at the same time, that might change your situation too.
Sure.
Okay, anything else from anybody else?
Okay.
Okay, I'll see you guys all 11:30 if we don't
Thank you.
contact you before
Thank
then.
you.
Have a good evening.
Thank you, Judge.
Thank you.